I'd like to welcome everybody and thank you for joining us today. For those of you that don't know me, I'm Kim Hutchinson, the Executive Director of the Virginia Farmers Market Association. VAFMA is a member-based organization working on the sustainability of farmers markets in Virginia. One of the things we do is provide educational opportunities for farmers market managers and vendors. We are currently scheduling a slate of webinars for 2023. So if you have specific topics you would like us to cover, please let me know because we develop these topics based on your feedback. Before I begin with today's webinar, I'd like to introduce you to the newest member of the VAFMA family, Angela Duncan. She's our new administrative coordinator, and we are so thrilled to have Angela working with us. But many of you may know her because she also is with the Family Nutrition Program, part of the Cooperative Extension, works with Meredith Ludley Johnson up in Blacksburg. I would also like to ask all of you to save the date, January 18th. That is VAFMA's 2023 Virginia Farmers Market Conference, and it will be a one-day conference that's held online. And this conference will be from 9:30 to 2:30, and we will be sending out more details. So if you haven't already, please join our email list so that you can get the information, and that is on our website at vafma.org. We have a lot of exciting topics and speakers already lined up for the conference, including going over topics from marketing, social media, and food access. So please make sure that you check us out. VAFMA members will also want to save November 9th. That's the date of our annual membership meeting and our board election. We will be sharing our plans for 2023, and we'll be listening to your feedback as we develop our plans to move forward as an organization. There will also be a facilitated open member conversation as part of this membership meeting, talking about the challenges, successes that markets and producers are having at markets and what we can do to help you with that. VAFMA members will receive links and details to all of this next week. Now I'm going to turn our attention to today's topic, risk and liability at farmers markets. This is a topic that unfortunately is coming up more frequently. I am now regularly receiving calls about situations where market managers, volunteers, and vendors are being involved in lawsuits and other issues related to farmers market operations. These touch on everything from food safety to competitive practices to weather issues to racial discrimination. These calls are why I knew we needed to offer this webinar today. So I reached out to Katie Atkinson of New Oak Insurance and asked her to lead this conversation because she is very familiar with farmers market operations and has been one of our go-to people on all things liability and insurance. Katie partners with individuals and local businesses to develop risk mitigation strategies and to protect their most valuable assets. She's excited to share her knowledge with us today, and it's also open to meeting with you individually. So with that, without further ado, I'm going to turn the webinar over to Katie Atkinson of New Oak Insurance. Please put all your questions in the chat. I will capture them and I will ask Katie. So with that, Katie, take it away.
Perfect. Thank you so much, Kim. And thank you for the opportunity to speak to Virginia Farmers Market Association members and also non-members. This is a great opportunity to just go on ahead and learn all about the things that you wish you knew about insurance. So today we're going to be focusing on the risk and liability of running a farmers market, and we're going to try to handle it from both sides, right? Both if you are running the farmers market as well as you are a vendor. And of course, there's going to be some overlap and a couple of things that we touch on each. So a little bit of housekeeping here. Who am I? You're about to hear me talk about insurance. What is my perspective? So my name is Katie Atkinson. I am the founder and owner of New Oak Insurance. We are a boutique and independent insurance agency in Chesterfield, Virginia. What that means for you as a consumer is that I work with not only one company, but many. I've been in insurance my entire career. So I've been in insurance for 7 years. I worked my way from a customer service agent at a local independent insurance agency to the lead commercial division account manager and the go-to person for all things commercial. After living through the pandemic, it didn't seem as crazy to open up your own business. I'm sure there are a couple of those in this call today, and decided in October 2020 to take the leap of faith and start my own insurance agency. So New Oak Insurance. Of course, insurance can mean a lot of things. So what do I do specifically? I work with small business owners and am an expert in property and casualty. What that means is we specialize in auto, home, and business insurance. So the meaning of the talk today is to give you knowledge about what I'm seeing in business suits, especially. and what that means for you running your day-to-day operations. So I am here to share my time, knowledge, and expertise with you. I also am an expert with life insurance, especially for mortgage and key man insurance, but we're not going to be talking about that today. All right, you guys, we are going to get to some really meaty stuff. You guys saw the outline that we're looking into. So very first thing within all of the meat that we're going to be having, I am not a lawyer. Insurance and the way in which people sue people is all about contract language. So let's first say, I am not a lawyer. I am an insurance advisor. I am only responsible for my clients. All of the content contained in this presentation is generic. Your needs are specific. If you've seen one farmer's market, you've seen one farmer's market. You haven't seen all of them. So only your insurance advisor can ensure that you are fully insured. So make sure that you have a good one and that you share all of your different avenues with them. If you need an expert, I am currently accepting new clients. All right, the meat of what we're going to be talking about. Where we're going to be spending most of our time today are the risks when starting a farmer's market or when you become a farmer's market vendor. The things that we see when you're just even considering, okay, if I want to be a vendor, do I need to have a business? Do I need insurance? What does general liability insurance actually mean? A lot of people just say you need 1 million, 2 million. Okay, what does that actually mean? And then everything in between. And then a couple of risks that I've seen while working with my farmers markets and partnering with, VAFMA as well, and listening to all the stories, the things that I hear about the risks and how when I look at a farmer's market, what I look at for volunteers, employees, contractors versus board members, and the different, insurance, but also just things for you to realize, fire and wind, food safety, delivery, even some property coverage. So we're going to only briefly touch on that. And then this talk is meant to be for you. It is for your information. It is, there's a lot in here. So I encourage you to please put in questions in the chat. Sometimes the bunny trails that we take during these talks are the best. Just to give you an idea, the meat of everything I've talked about will be about an hour 15. So we have plenty of time within the 2 hours that we've allotted for questions. So please do not hesitate. All right, first and foremost, why do I need insurance or a business entity? It's talking about starting your farmer's market or your farmer's market vending service. I hate to be the one to tell you this. Hopefully I'm not the first one, but anyone can sue anybody for anything nowadays. That doesn't mean that you are actually going to be followed through with the suit, but that does mean that you need to be prepared and that you need a couple of tools in your back pocket to protect yourself from said suit. Even just having to protect yourself and have a lawyer to say, hey, they didn't do anything wrong can be incredibly costly. So why else? So a couple more supporting factors just in the society that we find ourselves in. If you are a public facing vendor, whether that be a farmer's market that interacts with the public, even if you're just selling goods at the farmer's market and to your neighbors, that's it, everything's okay. The second thing you're going to hear me say a lot this presentation is that everything's okay until it isn't. So these are ways in which we protect ourselves because we live in a litigious society and people have a very long memory. We're also looking to protect your personal assets, then since things can be extraordinarily costly. I have a couple of different examples on that, so we're going to wait. And then how do you protect yourself and your business from these costly lawsuits? Again, not even in the award of, like the loss, but just in having to hire a lawyer and say, I didn't mean to do anything wrong. So first and foremost, the first thing that you can do for yourself is form a business entity for your new venture. What that does specifically is sets apart your personal assets that you have in your personal name versus the business assets. It is a very important distinction and I highly recommend it. Whether you're looking at it, please consult a lawyer or an accountant for either an LLC, a nonprofit, maybe a for-profit corporation. But there are a lot of different consequences to which business entity that you choose, whether that be tax, like the tax liability associated with it and such. From an insurance standpoint, it's the perfect thing just to help start that separate liability. So consult a professional about which entity you want to choose, but this is a great place to start. All right, so the next thing, so you've started your business, you have your business entity formed. Now let's look at getting some general liability insurance, even before we get to the farmer's market. And why would we do that? This is another layer of protection to keep your business running smoothly. And the biggest thing that we actually see is just the peace of mind of when if and when you do get sued, you can turn in the claim to the insurance company so that the insurance company can do an investigation, hire and appoint a lawyer for you so that you don't have to take on that cost as an individual or as a business. You can keep running and doing the activities that you do every day. So I thought this was interesting. So this is 10 most common and costliest small business claims as of April 2020. Now, this is specifically for small businesses, so not only farmers markets, but I think it's important to look at the landscape and how it's been changing. So the first thing we're going to see is the most common claims that insurance companies get nowadays are burglary and theft. I can definitely attest to this. I work with a lot of contractors where equipment is stolen left and right, and they're trying to keep their equipment under lock and key. It's just people looking for an easy way to make a couple extra dollars. Now, interestingly, the most costly claims that we're seeing nowadays are for reputational harm. Now, part of that may be, if you remember Chipotle a couple of years ago, when they had that E. coli breakout. So that not only stopped their production right then, but it was the trust that they then had to continue to regain and the reputational harm that came from that food outbreak. They did everything within their power to be able to keep, their business going, keep their customers safe. It just happens. But their reputation definitely took a hit due to that. And I would definitely wager that they probably had insurance for that because it was a costly marketing campaign afterward. Second thing that we see are vehicle accidents and fire. And then of course, product liability. That's something that you as a vendor definitely need to know, whatever your product may be, whether that's candles, you're looking at the glass shattering later, whether that be food products, like whatever that may be. It only takes a couple of claims and they can be big ones. All right, so this is the meat that we are going to be spending through the presentation, and we're going to be defining what each general liability limit means, but more importantly, educating you on why we include it, the claims that we've seen, and what it means on a day-to-day basis. This is where if you also have any questions, I highly recommend putting it into the chat so that we can talk about it. And again, this is not an intuitive thing. I know insurance is not the most fun thing to talk about, but when it matters, you're gonna wish you knew about it, and I'm gonna make it as fun as we possibly can, or at least interesting. All right, so the very first thing that we're going to discuss is the each occurrence limit. Because when you give that certificate of insurance that your market manager has asked you for, and as a market manager, you have asked for, I certainly hope, what we're talking about is the each occurrence for a bodily injury or property damage to a third party. So this is where general liability gets the idea of the slip and fall insurance. So slip and fall for bodily injury is the most common thing that we see. Now the aggregate is all the way at the bottom, but these two are tied pretty much. So that's why I included on this slide. The aggregate is the total amount that an insurance company will pay during a policy period. So whatever the effective date is to the expiration date. Typically it's a year, but maybe it's not for your policy. It's whatever that policy period is. So what I want you to think of during this is that the aggregate is your bucket. It is the bucket of money that the insurance company will pay. And then the occurrence is the ladle in which we'll be able to pay per claim. So up to any one claim for an occurrence, for this example here, we'll pay up to $1 million. But then during the year, we'll pay up to $2 million. I mean, theoretically, you could have 4 claims up to, $500,000 a year. I certainly hope not, but you absolutely could. That's what that means. All right, so let's give you a good claim example of bodily injury specifically. Now, this is actually a real example taken from the Farmers Market Legal Toolkit. I've included all of the sources on my slides as well. So this was in Capital City Farmers Market in Vermont. A customer was going into the farmer's market and tripped and fell in an unmarked pothole. Unfortunately, the poor thing broke their arm. Now, it took a couple of years, but 3 years after the incident, let's just let that sit for a moment. 3 years after this has gone through, the claimant decided to put in a suit for the bodily injury that took place at the farmer's market. And they were awarded $110,000 in damages. Now, per state, the statute of limitation changes. So this was in Vermont specifically. So something to also keep an eye on. All right, the next meaty portion that we are going to be talking about is damage to premises rented to you. Another way that I like to say this is in what it is known for, and I wish that they printed it on here, but they didn't ask me, so they don't print it on there, is fire legal liability. This is specifically if you are renting a space and then a fire breaks out in that space and damages the property that you do not own. Because you don't own that spot, but you are legally obligated to take care of it, right? So this is more for like a retailer specifically. And I know for farmers markets, a lot of it is open air farmers markets, but I wanted to include this in case you do like a holiday show, maybe. Like here in Virginia, we have the Richmond International Raceway. So when they are gathering their certificates of insurance, they might include, you have to have damages for premises rented to you, just so that you're aware of the coverage and something that you might see. Typically, this is a little lower, around $100,000. This is what I usually include is up to $1 million. There's a lot of small retailers that share within bigger spaces. So I want to make sure that it's not only, the portion of the building that you occupy, but also the large building as a whole. So for my hypothetical claim example, let's use the fried turkey special. So somebody has decided to go to a holiday farmers market over at the Richmond International Raceway. Maybe they told the manager they were doing fried turkey. Maybe they didn't, but they decided to do a fried turkey special. So they have their fryer set out. They have a cooler of turkeys getting ready to go. They've trained their employees on how to do it safely, but they don't realize as they're talking to customers, time goes on, that at the very bottom of the cooler, there's one turkey that's a little too cold. And they just aren't thinking about it and go on ahead and put that almost frozen turkey into the fryer. Well, we've all seen those videos. We know what happens. The turkey fryer immediately bursts into flames and starts ensuing the building around it. Now, is this an extreme example? Yes, but it helps show the claim that we're looking for. Any questions as of yet? Say we're doing good? All right. The next thing that we're going to be talking about for general liability is the medical expenses. So med pay. The cool thing about med pay is that it is the amount an insurance company will pay without proving fault or liability. Now, how is this different from what we just talked about with bodily injury? For bodily injury, you have to prove that you were legally liable. So in that example, there was a pothole that should have been taken care of. That was a that was a hazard, essentially, that somebody tripped and fell. But for med pay, it might be something that we're not proving fault. It's essentially, I'm so sorry you got hurt. Here's up to $5,000. Please go away. My example for this is unloading at a farmer's market. So here in Richmond, Virginia, there are a lot of bike lanes. This is somewhat recent. Within the last 10 years, we've added a lot of bike lanes in the area. Some people are still adjusting to it. This actually happened to one of my insured. They were unloading, just getting ready to go to their next destination. They opened up their car door, and then a cyclist comes out of nowhere and runs into the car. Now, it resulted in minor injuries, but they exchanged information and they were able to get some medical payments. Because who do you really say is at fault? Is it the person that opened the door, or is it the bicyclist? It was just a freak accident that happened that resulted in minor injuries. So that's exactly what MedPay is for. Another thing that, and we'll bring back MedPay later on when we talk about volunteers as well. All right, personal and advertising injury. So when you look at a certificate of insurance, it specifically says, you know, personal and advertising injury, but they're actually two distinct things. So we have personal injury as well as advertising injury. Sometimes the two go together, but they're two separate things. For personal injury, we're looking at things such as libel, slander, invasions of privacy, or essentially any way that a person has felt, you know, harm, versus advertising injury. Liability caused by harms from claims such as a misappropriation of advertising ideas, styles of doing business, or copyright infringement. So typically what we see is $1 million of occurrence limit again for your insurance. So here's a great hypothetical claim example for personal and advertising injury. So an organization takes a picture of a customer shopping and does not realize that their credit card information is visible. They post the picture to social. That is a very big, oh my gosh, no, I did not mean to do that, but they did it. So what if they do end up getting sued afterward? It was an accident. They didn't mean to. There is a little bit of nuance in this. It's why I chose the example as well. Sometimes personally identifiable information can be excluded from general liability policies. So if you take photos of the public, talk with your insurance advisor. With all of the information available nowadays, there are a lot of little nuances that have started arising out of this growing behemoth that is social media and posting everywhere. There's also another thing I wanted to note, because advertising as a whole, we're talking a lot about general ideas, right? But advertising does not include non-compliance labeling of products. If you are advertising your company on a product and you are not looking up the regulatory laws and information that should be within your labeling, and for some reason you just don't look at it, and then you're found to have not been following the law, not because you were just because you didn't look it up. Sorry, that's not good enough. There is an inherent responsibility to be able to conduct business in your chosen vocation, right? Like, I'm an insurance agent. There's a certain level of conducting business and knowledge that I am expected to know as an insurance agent. So the same understanding goes to food producers or food labelers, maybe even candle makers, however it may be. So that's something that I really want to encourage people to continue to go look at your state's labeling and food safety requirements to figure out what you need on your labeling, because it is not going to be covered on your advertising injury. So just something to note there. All right, this is a big one, because sometimes I've seen general liability policies where they just don't include products or completed operations. And this is an important distinction between bodily injury as well. I'm just assuming that we have some food producers here. Your product, right? If you end up causing bodily harm from the sale of your product, whether that be foodborne illness, or I work with a lot of decking contractors, right? When completed operations and products, the idea behind that is that you have a product or a project that you have worked on, you've put all this, time and energy into it, and then you give it to the customer and you leave. What happens then if the client gets hurt after you leave? This is where the coverage is going to come from for your foodborne illness. So if somebody gets sick after ingesting your jams, if your deck, it turns out, wasn't constructed just right, and then they have a party and the deck completely collapses and people are hurt from it. This is where the coverage comes from, not bodily injury.
So I have a question. I have a question for you on that before
Absolutely.
you move on. So, but that is, the coverage is only true and applicable if the person, my understanding is that the coverage is only applicable if the person is compliant with the state laws and regulations. And so they have to have followed the regulatory compliance from either Department of Agriculture, Department of Health, et cetera. And if they haven't, then the coverage is not valid.
Exactly. It can be a very easy exclusion to give the insurance companies, especially if it's something, again, that is a reasonable expectation of you, as a professional, going into these duties. Absolutely.
Right. Yeah. So if a market manager has not made sure that a producer's products have been approved by VDEX and they have not been approved and somebody gets sick, then the market manager's insurance isn't going to protect them.
Yeah, correct. And then it's even one of the slides as we go later on is talking about, where is the line between the farmer's market starts and the food vendors stop. It's a very gray area because exactly what you're talking about. There's a certain level of trust that's implicitly given as a customer when you go to a farmer's market. And because of that trust, the customer is assuming that, okay, this farmer's market has said that this vendor is okay. If somebody gets sick, it's very easy for them not only to sue the vendor, but then also go to the farmer's market itself. Because, if they aren't checking, why weren't they checking? The onus of protecting the public is really shifting a lot toward business owners and people that are bringing everybody together. It's definitely a shift that we've seen within the last, especially the last 5 years, if not, the last decade or so. Yeah.
It's the biggest issue we probably deal with on our side. And the other challenge is that the market manager may have validated inspections and product approval at the beginning of the year when they took the vendor application, and the producer then goes and introduces additional products that have not been inspected and they have not been approved, and they haven't followed up. And so, my understanding is, and I think you've just verified this, that any product has to be compliant with state standards, and if it's going to be covered under insurance in case of something happening.
Yeah, absolutely.
They have to follow the law, basically. Do their due diligence.
Yep. It's definitely a due diligence. And then you're even starting to, if you knowingly break, if I know there are rules and regulations that I should be following, but I'm just not going to worry about it. I'm too small. That's from an insurance standpoint, that's a very easy exclusion because it's a criminal act. All criminal activity is absolutely excluded 100%.
Right. And we're seeing that in Virginia where it's being deemed a criminal act of negligence. So, and then back to when you were talking about labeling also. So there are regulatory requirements from the Department of Agriculture, et cetera, regarding labeling of products. And so if products are not appropriately labeled and somebody gets sick from that product because they have not been appropriately or accurately labeled, then the liability insurance is also negated, right? It's not covered.
More than likely not. Like every insurance contract is a little different, and we do try from insurance, we do try to give the benefit of a doubt, right? But like if it's something that you definitely like should have known, and somebody like, I think everybody nowadays, even just from my experiential, right? Like you see allergen information everywhere. There should be allergen information if you are giving food products, like, and it's not like written on there, that's a very easy exclusion.
Yeah.
And in my research for everything, I actually found a case. It recently happened. I mean, it's not in the US, it was in the UK, but it was a restaurant owner that recently changed his recipe to include almond flour. And one of his clients came in and asked like, hey, are there any nuts in this dish? The restaurant owner said, no, there are no nuts.
Right.
Unfortunately, the man passed. And so they actually found the restaurant owner was, they charged him with criminal, I think specifically in the UK, they said gross negligent manslaughter.
Right.
And so he's spending 6 years in jail for not disclosing the information.
Yeah, we've seen that here in Virginia too. And can you explain a little bit further, or take it the next step? So if a market manager, because it's very clear what the law is in Virginia, that you must meet Department of Agriculture and Department of Health standards on labeling as well as on food inspection, and that all products have to be approved before sold, et cetera. That the products have to be approved and sold, and the recipes approved, et cetera. And so, which we will send that out as part of the deck as to what the requirements are. So if a market manager knowingly or unknowingly knowingly allows a non-compliant vendor to sell. And we had this past summer where market managers have been told by Department of Agriculture and us that vendors are non-compliant, that they have products that are not approved to sell. And if they still allow them to sell and somebody gets sick or something happens because of that product that was not approved to be sold, then the market manager is now responsible, is now liable, correct?
Yeah, in a lot of my research that I was doing, there's talk of like implicit responsibility, right? Because you as the host of a farmer's market, right? You are essentially saying like, as this farmer's market, like this vendor is welcome here because they meet our standards. Well, if it turns out that you don't have any written standards and you don't actually have anything, like you should. And it's not, and just to kind of go back to what you were saying, especially if they've received notices from Virginia, those definitely matter, because that is a solid paper trail that an insurance investigator can very easily say, like, no, you were essentially engaging in criminal activity when you were forced to shut down. Like, we're not covering anything. It would be like if I know it seems different, right? Because it's a farmer's market, but like, if a restaurant gets a health violation where they have to close, they have no choice. They close.
Right.
Like, and there would be absolutely no coverage if they continued to operate.
Right.
Like maybe, I think, especially in Virginia, we're still in this bit of growing pain. We're like, hey, you need to close, but it's just not the processes, or it seems to be like they're coming down on it. So those processes are coming in place now, but we're just in that growing pain of getting it in place.
Right. And I think that that's one of the things that I appreciate you mentioning, and to reiterate that, you know, we're talking about two different issues here. We're talking about liability of where it's going to cost you money because your insurance is not going to cover your negligence, but it's also a criminal activity. The Department of Agriculture and the Department of Health regulations are law in Virginia. And if you are knowingly not following the law, then you are breaking the law. You are now complicit, and then your liability insurance isn't going to cover it either. And so you're creating, you know, you've got both the criminal activity as well as, you know, negligence. And so your insurance won't cover you. So I just wanted, you know, the farmers markets are happy places and we love farmers markets, but we have laws that we have to follow. And again, this is the biggest issue that I see, and scary things are happening. So just wanted to make sure we talked about it. Thank you.
Absolutely. Well, and I think to your point as well, I think the trend is just that we're going to keep seeing things continue to, like, state agencies, especially, to continue to intervene, because farmers markets are only growing. They're only growing, they're only like continuing to flourish. So because of that, there's going to be more regulation. There has to be at this point.
Thank you.
Oh, great question. Thanks for that.
Thank you.
Yeah. Any other questions as well before we show the claim example for completed operations and products? All right. So on our next slide, we're just reinforcing essentially what Kim and I were just talking about with the product liability as well as completed operations. Because as a producer and as a vendor, once you've created a product, it essentially has its own life. You are giving it into the hands of the consumer now. So this is the insurance that covers that after you pass it along to the consumer. So this is exactly so this is a different example actually than I was mentioning of the UK example. But this is a separate one where a Michigan man bought food at a restaurant and became ill and almost died specifically because of E. coli. So eventually he received a settlement of $695,000. I do want to take a moment at that and just kind of let that sit in for a moment. $695,000. There's a reason why we have the limits to $1 million. A lot of these suits are just becoming more and more costly. So it is it's just standard now that we sell $1 million of occurrence with $2 million of an aggregate, because that's what we're seeing in the market. Yeah, and if they specifically, if they didn't have insurance for all of this, then the restaurant would have had to pay for it. All right, so we covered a lot of meat within the last section. You guys just got a lowdown on a very high look at all of the process of a general liability policy and what it is that you're actually paying for and the coverage that it is in a general liability policy. So I was wondering if I could get a little bit of feedback here. With everything that we just talked about, how much do you think a general liability policy is for a farmer's market vendor and a farmer's market? Because there's a lot of coverage here. So do you think an annual policy is $200 to $400, B, $500 to $1,000 on average, C, $1,000 to $3,000, D, $3,000 to $10,000 a year, or E, $10,000 plus? Say, what do we think?
So we're kind of all over the place. We have some folks that think that vendors are A and that markets are D. We have some folks that think that markets are B or C.
Okay.
Nobody's put E up there. I think that's the only one that nobody's chosen.
Yep.
We do have Lincoln Park that says they pay $350, so that would fall in A.
Yep. Okay. Yep. And then of course it's going to vary from like, state to state. So I wanted to engage this question just to see anecdotally what it is,
Yeah.
All right. So we kind of have a lot of B's, a couple of C's,
a lot of B's,
a few A's, but mostly B. Okay. Nice.
Yeah.
So I have some great news, folks, especially for vendors, and again, we're just talking liability only. So we're not talking about any products or not product, but like the property itself. So like the tent that you own it, things like that, like just liability in case you get sued. So typically what I see on a day-to-day basis, and of course this changes depending on what your business operation is, but a really good starting place, folks, is $200 to $500 for a vendor. Day in and day out, mostly what I see is right around $300. So Lincoln Park's pretty spot on for $350. Depending on the farmer's market that it is, it can be a little bit more, right? If you have more farmers markets all under one LLC, somewhere in the $500 to $1,000 range is usually pretty good. If it's smaller, maybe it is closer to 500. But I just wanted to get just set an idea that it might not be as expensive as you think. I know we're talking a lot about the ways in which somebody can sue you, and that can be a little scary. But because it is happening so often, like insurance really does try to make it affordable, So I I hope that is a little bit of a welcome answer for people. All right, so we touched a little bit about this, Kim, with our discussion, but I just kind of wanted to reiterate and maybe open the floor for questions as well, because where does the farmer's market stop and the vendor space begin? The problem is the interconnectedness of it, right? Because if somebody is going to sue a vendor, it is very reasonable for them to then sue the farmer's market, depending on what it is, right? So as a market manager, just like we were talking about, you have an implicit legal obligation for the safety of your customers. There's a lot of trust that goes into just opening up a farmer's market. People are trusting that you've chosen the vendors that will represent you well and that will keep them safe. So just make sure that you have those processes in place and you're familiar with the state laws. Also, as a market manager, if you have those written procedures and you have that written requirement in, that means a lot, because it's also showing a good faith effort of trying to keep people safe and trying to vet your vendors as best you can. Get something in writing. It is the best for you. Have that documentation. It could really help you in the future. So in talking about the documentation requirements, I wanted to touch a little bit about certificates of insurance, because this is usually when a client comes to me. They say, hey, Katie, somebody recommended me to you because I need a certificate of insurance. I say, cool, let's talk about all the different policies. They go, no, I just need a certificate of insurance. Okay, let's talk a little bit about what a certificate of insurance is and why it is being required of you. So a certificate of insurance is a snapshot of the day that, according to the day that it was issued. I had one underwriter that used to say the certificate of insurance is as good as when the ink was dried, because that's literally what it is. It's as if you took a photo of somebody's insurance and then you send it to somebody, because it could change in the future. They might not pay their premium in the future. With just a certificate of insurance, you wouldn't know. So how do we further protect you as a market manager so that you know when things change on your clients' policies? I've even had people before, luckily not with my clients, but I've heard of stories where, you know, people buy the limits that they were supposed to, and then the next month they have trouble paying, or not trouble paying, but they just want to lower their premium, right? So they just go on ahead and lower it. Well, that's not what you are gonna have for the year, but now you've changed it. So as a farmer's market manager, how are you supposed to know about the changes on a policy? First thing that you can do is request to be a certificate holder. That is essentially what we just talked about, of it's as good as the ink dries on it. You are saying, hey, we're going to be conducting business soon. I would like a snapshot of your insurance. That's what it is. The better option is to request to be an additional insured. As requesting to be an additional insured, well, we'll get into that a little bit more, but that's the better option for you. The best, if you want to know if there are any changes, and again, I'm not a lawyer, so you do need to check on what your state requirements will allow you to do, because some states are funny with this. But you can request to be an additional insured. You can request a waiver of subrogation if you'd like. And most importantly, request to receive cancellation notices as allowed in your state, so that essentially if any changes is made, you will know about it. All right, so what does it actually mean to be an additional insured on somebody's insurance policy? Essentially, it is that extra layer of protection, and it's continuing during that interconnectedness of, okay, this vendor is liable for something that happened, and me as the farmer's market manager, I may be implicated, or like me as the farmer's market rather, may be implicated in it as well. What this, per a written contractual agreement, always important to note, per a written agreement. The better way to explain this is through a claim example. So let's actually look at the claim and get an idea of what we're talking about. So we have our additional insured hat on. So we have a barbecue vendor that set up a grill with a long extension cord to a nearby building. He checked, make sure everything's okay, just gone ahead and set it up. So a customer comes through and trips and breaks their arm. So in my mind, how I'm imagining this is that this cord is within that shared space of the farmer's market, right? Not just within their tent, but like wrapping around to a building somewhere. So once this visitor files a lawsuit against not only the vendor, they sue the farmer's market as well, since they allowed the vendor to set up this like essentially tripping hazard, but they didn't realize it was a tripping hazard at the time. What this insurance does is that they recognize, hey, during the course of business, like we're going to be working together. There might be something where you do something and I may be implicated as well. For the additional insured, it's saying that for that claim, once the customer puts that, claim against your insurance, if they then go and sue me, I can put it on your, like you were the one that started it, I can put it on you as well. It doesn't have to go separately because you started it. It gets a little tricky, but that's the basics of it, essentially. Is that as an additional insured, you're saying that things are interconnected and there might be something where we both get sued, but since it was you that started it, I'm going to be able to use your insurance as well. So it kind of helps around. So a little bit more about that interconnectedness we've been talking about. And then I also have a really good YouTube video if you want an even more succinct explanation of it too, because some of this can get a little tricky. And the problem is different insurance companies have different definitions of what an additional insured is. So if you really want to know, you should ask your insurance advisor or look and see what it means to that company. But this is just a generic over the board, Yeah.
So are you saying that market managers should have their vendors list them as additional insured on their applications?
So if I was a market manager, that's absolutely what I would do. With what I have seen as an insurance agent, yes, that's what I would do. Again, talk to a lawyer, make sure it's okay with your state, but that's what I would recommend.
And if you would send me the YouTube video, we'll make sure that we include that with all of our materials that we send out.
Absolutely. I'll be sending the slides out as well if you guys want that. Yeah. And I try to put I put all of the sources to like, okay, I want to learn more about the additional insured on each slide as well, so that you can see some of where the information came from and another example, I like to give the option of, as I say, like nerding out as much as you want about one thing, and being able to read a little bit more about it on yourself.
If I remember correctly, it's not that expensive to add on as an additional insured. I mean, it was nominal.
For one person, typically what I see is about, again, it depends on your business, but anywhere from $40 to the year to $100. And that's for a blanket additional insured. And what that means is that anybody that you have a written contract with or a written agreement, like they are going to be an automatic additional insured. So I have a couple of like painting contractors that do this. For some of my vendors that go to multiple markets, I suggest doing that because then they're listing, again, as long as there's a written agreement. The interesting thing is they don't even, like for some of the companies I work with, a written agreement can literally be anything, even if it's a napkin with a written agreement. Obviously a contract is best, but written. We typically don't work with verbal. Doesn't usually happen anymore.
So expand on the vendors that are selling at multiple markets. You want them to do what?
Add their, so they add a blanket additional insured endorsement. So what it's specifically called is an automatic status when in written contracts with somebody. But in the insurance industry, sorry, what we call it is a blanket, but I guess that can be confusing. But what it means is it's an automatic additional insured status when you are conducting business together through a written agreement. So like I have one, for example, I have a painting contractor that works with a lot of apartment complexes. Like it would be a lot of work for us to list 20 different apartment complexes per thing. But what we can do is do an automatic blanket, but what it means is automatic status of additional insured. And then they still get all the same, coverage afforded to them. Great question. And sorry, I try so hard to stay away from lingo, and then every now and again it like pops up, and I don't intend to at all. All right. But yeah, great question. For waivers of subrogation, I'm not going to dive into this for the purpose of this discussion, because this is when most of the times that I see this happen is when somebody has a lease agreement between a property manager and a leasee specifically. So I just want you to know what a waiver of subrogation is, but we're going to skip it for the purpose of this video. So, and then my YouTube example, if you would like to learn more about it, but it doesn't affect a lot of farmers markets. Oh, this is a fun one. So, location of farmers markets and your risk. Please talk to the owner or manager of the property that you are going to be having your potential farmers market and get a written agreement. I know that everybody are friends and that we are all buddy-buddy. Everything is okay until it isn't. It looks like we may have a question as well. So I'm gonna hold off for a second. So Dale asks, my municipality told me I cannot instruct patrons where to go take shelter during a weather incident at our market. By doing so, they say we are accepting liability for them. What do you say about telling people where to shelter? That is a great question. I would say I'm not a lawyer to that one. I'm sorry, that's not a very good one, but yeah, it depends on what I would default to what the municipality lawyer told you to do. Unfortunately, even if it's, well, we're going to talk about weather a little bit later and the legal responsibility that you have. That stinks though. I don't know what state you're in, but that's a rough one. Say, yeah.
Yeah, what type of market are you, Dale? Are you a municipal? Are you run by Parks and Rec or a municipality, or are you?
See, maybe he's typing it out.
Okay, maybe so. And I would say, I know that this came up during COVID, that you need to have written municipal market in a city. Yeah. So if they're a municipal market being run by the municipality, then I would assume that they're on the municipal, they've got an emergency preparedness plans and all of that written down, and have the farmers market included in that. Gosh, I've never heard of that, but we can check into that, Dale, for you if you want. If you're in Virginia, I'm happy to check into that for you. If you want to shoot me an email privately, we can chat with our lawyer about that.
Absolutely.
And we also have a question, Katie, asking if you could speak about the cost and availability of single event coverage for a vendor or an exhibitor.
Yeah, absolutely. So what you're specifically talking about is special, well, here's the weird thing that I've come across in my search for insurance for my clients that I've worked with. When you are a vendor specifically going to as an exhibitor to a single event, I've actually had trouble getting this for insurance. And let me tell you why. In the insurance world, we're going, why are you only doing one? Is this not an ongoing business? Are you just, because it's hard to differentiate if you are, Oh, that's a different one. Okay. So for the single event, because it's hard for us as a insurance company to differentiate with the products and completed operations. So I'm selling this product just for this single day and then I'm done. Well, no, because somebody else has your product and now that risk is ongoing. From a price standpoint, I actually found it more expensive to try to do a one-day event versus an annual policy when we're just looking to see what the business is. I'm not sure like what business you're in, but I hope that answers questions. I actually found it a lot simpler to like the underwriting questions were, you know, more what I was used to when looking for an entire year versus a single event. It actually raised a lot more questions. Does that kind of make sense? I'm not sure what business you're in, or if you have further questions, I'd be happy to reach out separately as well. But if you have follow-ups, just let me know. That's what I'm here for. Dale, let's see, followed up with the storm related about, no, sorry, I'm in Illinois. Just curious because I get conflicting answers from insurance companies and from lawyers. I would say most importantly, what does your insurance company and your lawyer say? Because every contract is different as well. So I would want to, for you as a consumer, that would be the question that I would be asking is, hey, the insurance that is currently in place, you know, what do I do? Again, since it's a municipality, it might be that you're under the municipality's insurance and that's what they've been telling you to do and what those lawyers are saying. So I'm not sure the hoops that you're having to jump through there, but hopefully it'll, you know, I would go as direct to the source as I can, if that kind of makes sense.
So I have a question thank you for that. I have a question for you. Talking about Anderson's question about the cost and availability of single event coverage. You know, we have a lot of vendors that they vend at farmers markets, but then they might go do the Woman's Day at the racetrack, which has nothing to do with the farmers market, but they need to know whether, you know, do they need a different type of insurance or a special event insurance just for that event because it's different than the farmers market insurance, or is it all covered under their original policy?
Again, every policy is different, but in my, but from my understanding, as long as you're conducting business in the same way, right? It's the same type of business. It's the same type of risk, whether it be from one to the other, then it should be covered within the same policy that you originally had. Special event insurance is for whoever is hosting it as well. It's typically not meant for vendors. The people, again, if it is a vendor, typically what we see is like, why it was more expensive when I had been looking for my previous client, it was a baked goods store, right? And they were going to go to a couple of farmers markets during the year. Well, the only way that the insurance companies that I had would rate it, if we only rated it like a couple of days, is like large sporting events, right? So all of a sudden we're rating a small farmers market on a large sporting event scale, which is a much different risk. So we were able to find a policy that more appropriately rated and could address the risk best for a reasonable price as well. Does that kind of make sense as well? See, I love talking insurance. I can talk all day. All right. Great questions, guys. Thank you so much. If you have more, just please put them in the chat. We would love to keep the discussion going. So yep, for the location of farmers markets, I think Dale, you're right on the money. If talk to the municipality and see the way in which they want to run the farmers market as well. The reason I always say get everything in writing is because it's okay until it isn't. And I have a great, let me find it here. Oh, there we go. Pardon me there. All right. So we have a wonderful example of when everything was okay until it wasn't. So I actually found this case study while searching for this talk. This is as of October 3rd of this year. It is a case study of who owns the farmers market in Mulberry Market in Macon, Georgia. the skinny of it is that there was an incumbent company, so I believe it's CHW, was managing the market for 7 years. They ran it, things were going well in the community, and it was a very successful market. So it was a director and a couple of supporting employees. Well, the director retired. I guess after the director retired, there were some complaints, or it wasn't ran as well as what the employees had hoped. So on the next season of the farmers market, Mulberry Market starts opening up. CHW is the incumbent manager. They go to set up Mulberry Market. Goodness, that's a hard one to get tongue-tied there. Mulberry Market. So CHW, the incumbent, goes to set up their table. Lo and behold, somebody else has already set up Mulberry Market, and they say that they're under new management. The company goes, "What are you talking about? We run the Mulberry Market and have been doing so for 7 years." It turns out one of the previous employees decided to set up their own company and thought that the old company would be happy to take it off their hands, but she never talked to anybody, never checked with anybody about whether or not they could just take over the market, and then showed up to do so just on a regular day. So obviously, CHW has sued the new company, but things get a little interesting because now it comes out that there was no written agreement in place for the market to begin with. For the past 7 years, CHW, so again, the ongoing owner, they own the rights to the Mulberry Market, but they never actually paid for the space. It was a verbal agreement between the park association and the organizer. So literally, right after getting these suit papers, I forget which company it was, one of them goes to the parks department, online reservation system, and then goes on ahead and tries to reserve the space for the next year to further prove, oh no, wait, we're the one that's supposed to be doing it, because there was nothing in place. So unfortunately, this market has since closed because the park system, after receiving that reservation, said, nope, we are not, don't drag us into this. You guys need to figure out who is going to be, who owns the market, who's going to do it, and y'all need to figure it out. So unfortunately, the vendors are the ones that are kind of up a creek without a paddle. They've had this great market that, because there was no operating agreement or management, there is a little bit, again, this is ongoing too, so there's no resolution yet. It's a little bit of he said, she said, and there's no written agreement in place. So the reason I say this is, again, I know you've heard me say this a lot, but I see it a lot, that everything's okay until it isn't. So go on ahead and just get it in writing. And of course, I included the source for it. Michelle had an idea for Dale for the for the market safety. So another thing that I love about working with farmers markets is trying to problem solve together, and it's a great supportive community. So thanks, Michelle. All right. Again, we just talked a lot about the general liability insurance. We talked about the certificates of insurance, the additional insured. I mean, you guys essentially just got ways in which you can be sued and protections against said suit 101 in right around an hour. That's impressive. It's a lot of information. So please do, if you have any questions, let me know. I know this is a lot. I wanted to give you guys some resources though. And of course, the Virginia Farmers Market Association is incredible. The resources include the market manager certification. I'm sure Kim can tell you all about that. The Farmers Market Coalition, the Farmers Market Legal Toolkit, a couple of good things. And we're just over here on how to document for commercial general liability. We still have a second half of the talk where we're going to talk about some of the employment and such, but I wanted to take a moment just to give you some documentation resources. and move on too. All right, before we continue to risk at the farmer's market, are there any questions about the general liability or any of the, I know we talked about the interconnectedness, anything else? Yes, we're doing well. All right. In which case we're going on. Oh,
we do have a question. Hold on.
Oh, sure.
New question. It was suggested we ask to be listed as a certificate holder in addition to additional insured. Thoughts on that?
Yes. Certificate additional insured is more, this way we get notified if the insurance is canceled. So in Virginia, you still have to request a notice of cancellation as opposed to being asked to be a certificate holder. Like I think that's industry standard, but at least in Virginia, like being a certificate holder is just saying like, hey, I'm going to be conducting business sometime soon. Cool. Here's a certificate. Additional insured is while you are doing business, I am an additional insured while you're here. And then the notice of cancellation is after that. So that's like the next level of protection. So from my understanding, being a certificate holder doesn't equate to getting a notice of cancellation. They're two different things. Again, it might be a state thing, but like in Virginia, you have to request a special notice of cancellation and be added on the policy. Again, because we have those automatic status additional insureds, people aren't necessarily listed on the policy, so then they don't get the cancellation notice. You have to be specifically added to the policy to then get the notice of cancellation, if that makes sense. Like one does not equal the other. Because I think, is this Illinois? Yeah. Mm-hmm. Tell them, yep. Mm-hmm. Yeah, absolutely. Definitely something to check with your insurance advisor as well, but that's what I've always, like, that's how it's equated in my mind. So great question. Awesome.
And I will say, I know that there's at least one company that covers farmers markets that requires before they will provide a farmers market insurance that market provides them with copies of them being listed as an additional insured on every vendor that's in the market, proof that the vendor has insurance and that they're listed as an additional insured. Nice. And it's a large national organization, and we've started to see things trending in that direction. So that might just become, the norm as we move forward.
Yeah, I'd be very happy if that's the norm moving forward, just because it does continue to, in a way, it elevates the farmers market, right? Because it's ultimately for the safety of the vendor, the safety of the
market,
farmers market, and then also the customer if something were to happen. It's a very fluid thing. Oh yeah, I think I've heard of Campbell Risk. I don't have them specifically, but cool. All right. So we've gone through the bulk of the conversation. So these are a couple of add-ons that I wanted to include as well as risks at the farmers market, and of course continue to engage in the conversation and questions as well. So we're going to be essentially, the way that I broke up this talk, we were looking at just getting ready even before you go to the farmer's market. Now we're at the farmer's market. So all the volunteers that we bring in, or are they employees? Are they contractors? Well, what about board members of nonprofits and for-profits? Food safety, we touched a little bit on that as well with the completed operations and products. But this is just to kind of hit it home of like, come on, guys. Food safety is a great thing. We love food safety. We love it. I love it. I love food. So just continuing the safeness. Emergency preparedness and a couple of those resources as well. And then delivery services, because we are a fast society. We like things as quickly as we can. All right. Big disclaimer for this one as well. Because we are starting to talk about the individual, what constitutes more of the individual risks of businesses, this is even more contract specific, because we're starting to get into how companies define volunteers. versus employees versus contractors. This is incredibly specific to your insurance document. So I wanted to at least bring an awareness that there could be differences and to ultimately start the conversation between you, your insurance advisor. If you have any questions, please feel free to reach out to me. That's what I'm here for. So again, just for my disclaimer, we are traveling into the minutia of contract language. The examples given are anecdotal from my personal experience, and they may not be an accurate representation of each insurance contract. So please consult your specific insurance contract and speak directly with your insurance advisor to gain the most accurate information for your policy. Okay, disclaimer aside, we will venture on. So, volunteers. From an insurance standpoint, volunteers do not have the same rights and the same coverage as employees. For instance, if they get hurt, they do not have workers' compensation. They are not an employee. This is where the med pay, remember earlier when we were talking about you don't have to prove that you're liable, but you do have some medical expenses. That is the limit that we're looking at for, or typically it's a similar limit. Again, read your contract. But that's the idea that is associated with volunteers. It is a separate sub-limit, usually very small compared to what employees would be given. I even have run into definitions of volunteers and the coverage that is associated with them change based on, are they like fundraising telemarketing volunteers where they are calling people and raising funds, or maybe they are even going door to door raising funds. Are they performing the normal duties of an employee, such as if they are at your farmer's market and they're giving food samples? Like, what does that look like? So please always tell your insurance advisor who, like, if you don't have employees, oh, but I have my family volunteer. Okay, cool. They are still a public-facing ambassador for your company, for your brand, and they are essentially acting on your company's behalf. So I implore you to consider the applicable training for the volunteers and the procedural resources that you then want those volunteers to have. For instance, if they are giving food samples out to somebody, sometimes people are nice and they ask, oh, hey, is this made, a customer asks, hey, is this product made in a facility that has peanuts? Rather than saying, no, I don't know, some people just go, oh yeah, absolutely. Rather than coming to ask you. So have a couple of even some cheat sheets, like just a little bit of training for volunteers so that you also have something in writing just to help, hey, I really did try to train these guys and they just made a mistake. Like if it's an honest mistake, that's one thing, but just make sure you have it in writing so that people just don't, you never know what people are going to do. Just give them a little bit of guideline, just a little bit of training. That's all it takes. All right. Risks at the market, employees. So employees are afforded a similar coverage as an extension of your business. So things that we want to consider for our employees are the written rules and guidelines that we want our employees to follow. Because if anything does happen and they go against these regulations, again, we're human, that can't happen, but how you protect yourself as a business owner is having training where you train these employees and have them sign off on an employee handbook or an employee training saying, I received this training, I understand the risks, this is when this training was completed. And again, accidents happen. We're not unreasonable in saying people can't make accidents. What we're saying is protect your business and do your due diligence. If they need to have safe food handling before coming in and making your jam, for all that is good, give them some safe food handling training. As the owner, you are the one responsible for that because ultimately it's not their business, it's your business. And it's going to be your business that suffers if anything happens. So things to consider. A couple of other trainings that you can consider are even anti-discrimination training, sexual harassment training. The reason I bring this up is if you have multiple employees, what about employees harassing another? there is now even, this might be a new one for you guys, third-party employment harassment. Like, so it's third-party employee harassment. Essentially, what if your employee starts harassing the UPS guy? Every time the UPS guy starts coming around, your employee starts, they're just making jokes, they're whistling, whatever. Eventually, UPS guy's going to get sick of it, and they can then sue your company for it. Might not be covered if you don't have the correct coverage. Again, I know these are things when you get bigger, but I at least want you to have the awareness and just know that such a thing exists. That's one thing that I think a good insurance advisor does, is kind of give you a roadmap of not only where you are, but where you could be, just so that you know, oh, hey, there's something we talked about when I start hiring more employees. Okay. Another thing is to check with your state guidelines for workers' compensation requirements. In Virginia, we actually had a big overhaul in 2020, where Virginia has really tightened the requirements and also the fines if you do not have your employees correctly categorized. So like for subcontractors versus employees, the fines have grown a lot. I think for the first offense now it's $1,000. Third offense is $5,000, and then it can be additive if you continue to not categorize them correctly. Most importantly though, the thing that you should check is after how many employees, how much, when you need to add that workers' compensation. So what does that trigger? For Virginia, it's 2 employees or more. Important distinction, it can be 2 part-time employees. Doesn't have to be full-time. 2, there are 2 people or more. You need workers' comp. That excludes owners, so you can exclude yourself, but 2 people other than your owners, you need workers' compensation. All right.
We have a question about properly categorizing employees, which I know is a little bit off topic here. How do we determine if a worker is categorized properly? The Department of Labor is non-responsive to inquiry messages via voicemail and email regarding whether they're a 1099 contractor or whether they are an employee. And I know I've sent folks over to the IRS definitions, which are pretty clear. If it looks like an employee and it's doing the job of an employee, then it's an employee. But any thoughts from you regarding?
I think there's even a quiz you can do now on like the IRS specifically of like, they take you through a multiple choice, like, is this an employee or a subcontractor?
Is that on the IRS website or is that through the Virginia
I want to say it's the IRS. I want to say it's the IRS, but I haven't checked in a while. I'll have to double check and then get back to you on that one.
We'll see if we can find that, because I know that they're coming out and they're finding folks, and so many of our market managers are considered contractors versus employees, or are being labeled that way, and it's probably incorrect.
Yeah, the big rule of thumb that I've always gone by is for a contractor, do you tell them where and when to be, and do you give them the tools? If so, they're an employee. Because for a contractor, if you think of like, so I work with a lot of marketing agencies too, right?
Right.
So they subcontract work, but when they subcontract work, they go, hey, graphic artist, I need a graphic that looks like this, and I need it by this date. Here you go. And then they just give them full reign and power over it. So in that instance, the graphic artist is using their own equipment. They can do it on their own time. There's no difference. And then typically they have their own insurance as well. Yeah. Like that's very clear cut a contractor. Right. For employees, the big thing is if you tell them where to be and you give them the tools, they're more than likely an employee. Looks like we have another one as well. And if if a market worker has to go to the market, to manage and use the market signs, etc., that would seem to be an employee, not a contractor. So, okay. So essentially if a market worker is a contractor is what so they're like categorizing the worker as a contractor, but are they an employee?
Right. And I think the main issue, the other issue is, or the other concern is, if the person feels like they are miscategorized and aren't getting the responsiveness from their market manager, what do they do? Short of turning them in to the Department of Labor and filing a formal complaint with the Department of Labor, the state's attorney general, which is who's investigating all of this right now in the state of Virginia, you know, I mean, if you can't get the market man and, you know, and or quit so that it doesn't come back on you and you end up having to pay taxes because you've been miscategorized, what are some other options that you can do?
And
does this impact
like protect yourself as like the contractor / employee, but you're not.
I guess to protect themselves as the employee, number one. And number two, I guess where you're concerned, does this, you know, if a business is miscategorizing their employees and they refuse to do anything about it, does this negate their insurance, or how does this impact their insurance that they have for their employees and their coverage?
So this is within one of those growing pains situations, right? Where we are trying to figure out how to do so. A lot of this has to do with whether or not they lied on an application and what they signed and how they represented it to the insurance, essentially in like written form. How did they, like when you came to get insurance, were you trying to like hide the fact, or did you like at least say, hey, we have a worker, an employee, something like that, so we can appropriately rate the risk? A lot of it, again, within those growing pains, it's whether or not what I've seen is whether or not they lied about it and what the application says, if that kind of makes sense.
Yeah. But I think in the case of, you know, the question here for the sake of time, et cetera, you know, for specifics, I would certainly recommend that if an individual is concerned that they're being miscategorized, which puts them personally in jeopardy as well as the market, I would suggest that you speak to an attorney. If you're not getting any kind of help with in resolving this with the market manager, I would suggest you speak with an attorney. Or the Legal Aid Society if you can't afford an attorney, et cetera, and get some legal advice, because going to the attorney general, or, you know, like I said, this could come back on you and then you end up owing back taxes and fines and things of that sort, as well as the penalties to the market, which could potentially cause it to close, you know, the financial strain on markets that operate on such shoestrings, and then losing insurance coverage if they've committed, you know, if they've if they've misrepresented themselves and losing their insurance. So it's a difficult issue. I will say from my standpoint, I know that this is a very big issue in the state of Virginia right now, and that the attorney general has it on his top 10 list of things that he's dealing with. So
that makes sense. The laws that we've seen changing in the last couple of years.
100%. Yeah.
Yep. And, you know, a lot of this is also just doing the best that you can, like you said. So seeking legal aid, just even trying, it goes a long way of just trying to do the best that you can. Yeah. Because like you said, it's not a clear thing.
Where you're talking about, you know, written, and you're talking about training and, you know, written policies and rules of conduct, et cetera, for employees. Also, and you may be touching on this, but I would highly recommend that you put all of your volunteers through food safety training as well as racial discrimination training, and you do it all before they step foot in a market, and you have them sign something that you've provided that training, because this is the second most complaint that I get from customers that feel like they've been discriminated against or have been treated inappropriately at a farmer's market. And the majority of the complaints are folks that are volunteers that have caused the problem. And it's not been malicious. It's been, you know, ignorance for the most part, or being flip, or not being, you know, not knowing how to appropriately act in a professional environment. So I can't emphasize enough that not only should you do the training, of all of your staff, but also your volunteers, and then have them sign off that they have done that training, and that you do that every year.
Oh yeah, absolutely. Yeah, even though I didn't include it, it's a lot of this is a lot of overflow. So just I completely agree 100% to get it in writing and have them sign off. Like, absolutely. Thank you again for the questions. These are great. For the contractors, another big thing that I wanted to point out as well is the workers' compensation implication, right? Because if a contractor, so again, I work with a lot of like carpentry, like painting contractors as well. So every now and again, they have to sub out. So if somebody is injured while working for you and they do not have their own workers' compensation, so that will be covered under your workers' compensation. This brings an interesting point when you were talking about whether or not they listed as a contractor versus an employee, because maybe they have two contractors, but now they don't have workers' compensation. And to me, that gets in the fuzzy, like, ooh, this is gonna be a tough one, folks. Because again, it's okay until it isn't. If somebody gets hurt and then starts saying, well, wait, I should have had workers' compensation, but they were classifying me as a contractor, so now I don't. Like, I just see a lawsuit waiting to happen, is what that says to me.
Well, and you look at what happened with Philip Morris, they had 40,000 contractors on their payroll, and they got back charged. I can't even remember, it was $1 billion in taxes and fines for misclassifying people for years.
Yep. There was a local heating and air company in Richmond that the same thing happened to. And I think it was right before they changed the law, which maybe that was a good thing in hindsight. But I forget which one it was, but it ended up being a multi-million-dollar back taxes, even for like, when you say Philip Morris, okay, billions. And then this heating and air company that has like 100 employees, millions, like it adds up. And that's why the state is also buckling down on it. They're tired of not getting those taxes. So just think of how much nicer our roads could be, you guys. Come on. All those potholes in Richmond. Oh, anyway, I love Richmond. It's all good. Okay, so those were some of the considerations for contractors. And then just to echo, like Kim was saying, to get everything written and to also have your employees sign off. So take that extra step. Great question. Actually, do you want to, so Mary is asking, Kim, does the Virginia Farmers Market Association have racial discrimination training when talking about all of this?
We do. We provided, we have webinars that we have done on racial discrimination, as well as it's a module in our market manager certification program. And it'll be a module that folks outside of our certification program can also get by the end of this 2023, hopefully. So we've done, every year we do a webinar training on it and have those videos available for our members, etc. So sure, Mary, reach out and we'll be happy to get you what we've done. Reach out to Mary Delicate or to me at info@BAFMA.
Awesome.
Yes, unfortunately, we had volunteers that racially discriminated at markets. So we now have an entire racial discrimination training program. Yeah.
Let's just keep getting a little bit better, folks. Just a little bit better every day. All right. So continuing with risk at the market. So we've talked about volunteers, employees, and contractors. And now we have a little bit of a different scenario with board members. So we kind of have a pseudo thing here because they're not employees, they're not contractors, but now we have board members. So they can be from a board, both for a for-profit or a not-profit corporation. A couple of things to note when you are looking at having a board for your organization and how the insurance will look through it. Typically, you can exclude them. You just have to list them specifically as being excluded. Most people I see do this because they're not involved in the daily operations of the business. They are there to have, to help guide the organization and give advice. So we can exclude them from the insurance, so the workers' compensation insurance. Important things to note about having a board is that they do have risk and additional risk, since they are the ones making the decision separate from the organization to help the organization. That does open them up to the risk of being personally sued. So how do we help our board? We love our board. We want to make sure that we appreciate everything that we do. And we also want to make sure if they make any fiduciary mistakes that are improper, what can we do? Because as a board continues to grow, it might not be people that you know intimately. So as your board continues to grow, how do you ensure, because you want to make sure that ultimately your organization is okay with the board that you've set up. So one thing that I wanted to, again, just give you an awareness of is considering directors and officers insurance. So with directors and officers insurance, it's going to help protect that organizational leadership in the event that you are sued for any alleged wrongful act. Again, alleged, right? So we're going to be helping to hire that lawyer and go through the claim with you. So it covers executives, directors, and officers, and from liability arising from their decisions and actions taken on behalf of the organization. So a couple of things that we typically see are allegations or misstatements, maybe reporting errors of how the organization is, inaccurate disclosures, prospectus misrepresentations, and management decisions. What I like to think of when I think of directors and officers insurance is a condo association, because typically a lot of condos have directors and officers. And if there is a board makes a decision that somebody ends up not being happy with and attempting to sue, that's something that directors and officers insurance will look into. All right. This just deserved its own slide because it's something I love. I love food, and therefore I love food safety. So when starting your own food farmer's market, so as a vendor, maybe you don't work in food, but if you do have a farmer's market, you probably have a food vendor or two. So this is talking about some of those safety regulations that you need to be aware of. And especially if you're in Virginia, the Virginia Farmers Market Association is a great resource of all of the regulatory bodies and the different regulations that you should be adhering to. And as a market manager, it is definitely your responsibility to prioritize the safety of your customers and make sure that the vendors are following those safety requirements. So things that I wanted to note out then, if as a market manager, let's say you have somebody that, oh, well, this is just a good guy, like he's just a small producer, so he doesn't follow the food regulations, but it's fine. Like I know what he does and it's okay. Like don't worry about him, he's okay. So you are knowingly letting somebody not follow the protocol. If somebody gets sick, we just want to hammer home that it might be seen as making a conscious decision to follow against the law, and criminal activity on an insurance policy is excluded. Just wanted to reiterate that one more time, because I know we all appreciate our fellow vendors, and I know we have those people, like those small vendors, but if you are public facing and you are working with the public, you have a responsibility to follow the same food safety guidelines. It's important, folks. And then talk to the Virginia Farmers Market Association about the different regulations to follow, because they are the experts there. All right, so whenever we have an active nature, such as wind and fire, as a market manager, you are going to love having an emergency preparedness plan, having a plan written down so that you know exactly what to do. So when the time comes, you don't have to think about it. There are a couple of great resources to get one. The Virginia Farmers Market Association is one. I've also listed a link for the Farmers Market Coalition. There are a couple of case studies so that you can look and see what other markets have done as well and what their plans look like. For the wind specifically, for all of those tents, there are a lot, it is getting a lot more, how am I trying to say this? There are a lot more claims with winds and canopies flying than you may realize. I'm actually going as a vendor to another, it's one of those like trunk or treat events in Richmond, Virginia. And I'm happy to see that the event organizers are no longer taking the risk of having canopies unweighted. Like this organization, if you don't have weights on your tents, you are out. They are having you take down your tent and you're not allowed to vend. I think that would be a great change in the industry because of the catastrophe that it can cause. So one of the examples that I found online, it was in 2019 when the YMCA hosted a sporting event on a clear and cloudless day, nothing in the sky. All of a sudden, a tornado-like gust of wind came from nowhere and blew a vendor's canopy into onlookers, essentially. Unfortunately, one of those customers had a crushed forehead that needed major surgery to repair the damage. So she in turn sued the YMCA and also sued the vendor for the tent. It only takes a moment, folks. Always always have weight your tent legs and have an emergency response plan if something comes into, like if something comes in on the radar, and when to shut down the market and just keep prioritize everybody's safety. So we do have another question. So, okay, nice, a couple here. So James asked, anyone recommend a specific weight per leg? We require 25 pounds. Kim, you and Mary might be the experts on that, on what the specific weight that you require.
The rule of thumb is always to go with, at a minimum, what the tent manufacturer recommends. And so we have market managers that do anywhere from 25 to 40 pounds, depending on what the tent manufacturer recommends, and to use good weights. And Katie can certainly share. We had a situation here a couple of years ago with a market where a wind came up and, ripped the tent out of the ground, unfortunately. And they had appropriate weights, and they had a weather plan and emergency preparedness plan. And they did everything right. And people got hurt. And, what protected them financially was that they had done everything correctly. But in this case, it wouldn't have mattered how many pounds weights that they had on the tent. But legally, they had the correct amount at a minimum that was required by the tent manufacturer, which, saved them on the negligence side. So at a minimum, we always say, minimum of what the specific, whether it's Easy Up or whoever it is that you're using, use the weights that are recommended by that company per leg.
Mm-hmm. Awesome. Thanks, Kim. Yes, James, you're correct that I should amend that to say that the weight should be what the tent manufacturer has, as opposed to just not saying anything. So sorry about that, and appreciate the recommendation. So I'll be sure to amend this later. All right, so see the manufacturer and see what they say. Okay, another thing that we wanted to discuss was the market, and this is one of the last topics of discussion, folks. So we're at the market delivery. So you have a couple of people make some orders. There are two ways that we can look at this. We have the commercial auto insurance. If you have specific vehicles that the business has purchased that is going to be doing deliveries. Another thing that we look at is hired and non-owned auto. This specifically is meant for delivery from people using their own vehicles. So this is not a car that you own, but it could be a car that you either hired, or just maybe it's somebody else that uses their car that you don't own. So that coverage is called hired and non-owned auto. I also like to point out this coverage, not only if you do delivery, but just to add to your commercial general liability policy. And the reason I say that is what happens if you send your friend to the bank on an errand, right? The market is closing for the day, you're closing up shop, and you really want to get your cash that you made to the bank before it closes. So while you are taking down your tent and such, you ask your friend that's been there with you, bringing you some company, hey, do you mind running to the bank and depositing the business money that I made today? And then just come back, we'll, pack up everything and be on our way. The friend, of course, wants to help, make sure that you get what you need. No problem. So they set out to go to the bank. On their way to the bank, they're hurrying a little bit, just making sure that they get there on time for you, and then not paying attention, and they accidentally cause an accident. The other party in the car, not only sues your friend just for their, normal auto insurance, but they then sue your company because your friend wouldn't have been on the road except because they were running an errand for you. It's the only reason that they were there. This is typically not covered unless you have hired a non-owned auto. I typically try to put these on my policies because you never know when you're just going to have a friend run an errand for you, and anybody can sue anyone for anything. And then, of course, this is also used for the delivery services. Again, just bringing a little bit more awareness as to what the insurance jargon is and how you can use it for your business. So I really appreciate all of the questions and commentary that we've had today. We've reached the end of our presentation, everybody. So I appreciate you hanging in with me. I know insurance can get a little dry, but it is interesting and it is important, not to mention just all the risks that we see nowadays, just even separate from insurance. It's just the different world out there that we're operating business in. So I wanted to open the floor again if there are any questions or any questions really. Let's see. And if not, I hope that everybody has gotten something out of it. Maybe you've received different questions to ask your own insurance advisor. Maybe you want to look into your policy a little more and see the different exclusions, or look into how to classify employees like we were talking about. So thank you so much for your time this afternoon. And I will be sending a checklist out. I'm glad that I wanted to wait and see what we have in the chat. So thank you for the recommendation. I'm going to save the chat as well. Because based just on everything, wanted to make it as tailored to folks as possible. And then, of course, if you have any questions, I am here as a resource, and my company, New Oak Insurance.
Katie, thank you so much. I am so appreciative of the time that you have spent with us, as well as the information. Never the funnest topic, different than how to advertise to get more customers, et cetera. But we'd like to not make our customers sick and not get sued over it. So very much needed and so appreciated. I can't thank you enough for putting this together for us today. Again, I asked Katie to come and speak with us because we are seeing so many different issues around liability here in the Commonwealth, even more so since COVID. And I cannot stress enough that, I joke and say it's not worth you losing your house over. And it really isn't a joke. It's not worth you losing your home over if you're not following the parameters established in the state and you don't have proper coverage. I will be emailing everybody a link to the recording of this webinar if you'd like to watch it again. In the email, we're also going to be sharing the dates that I previously mentioned for our 2023 online Virginia Farmers Market Conference, which is January 18th, and our VAFA member meeting, which is November 9th. I highly encourage those of you that aren't members of our association, I now will shamelessly plug us, to please join our association so that we can continue to provide you with the training and resources that are important for you as a producer, as a vendor here in Virginia, and as a market manager. We look forward to working with all of you. Regarding the to clarify regarding the racial discrimination training, we're in the process of developing specific training. We do have several webinars that we have done on race equity and farmers markets in Virginia. Then we also have done a program through our market manager certification class, but we will, and we're happy to share those, as well as we will be doing specific trainings that you then can go and hopefully implement with your staff as part of our market manager certified farmers market program. So more to come on that. Katie with New Oak Insurance, thank you so much. We appreciate it. And if there are not any other questions, then we will say thank you and good evening. And we hope to see you again soon. Thank you.
All right, wonderful. Thank you.
Thanks, Katie.
Yep. Say anytime for the Virginia Farmers Market Association. Anytime.